Hello, everybody. Good morning. And I'm glad to be spending this morning with you and discussing the FLSA and especially with its relations to immigration law. I know it's an area, it's a topic that needs to be discussed, that needs to be talked about, because at the end of the day, these wage and hour laws, these regulations, are meant to protect all workers in the United States of America. And unfortunately, most of the times, the workers that need these laws the most are the undocumented workers. Now, the problem is there's fear, right? And so that's what I'm going to address first, because without getting the fear out of the way, we can't learn and move on to the next topic, right? And so the biggest fear that many undocumented workers have in terms of being paid the appropriate wages or complaining or filing lawsuits is, well, am I going to be deported? Are they allowed to ask me about my status as a citizen or as a green card holder, or and my status in general in the United States when I file these type of lawsuits? And so let me reassure everybody, whether you're documented, whether you're undocumented worker, these laws are meant to protect you. They are not meant to be used as a sword against you. They are to be used as a shield for you and the rest of the workers in this country. And so the question of your status in an FLSA lawsuit, for instance, is an objectionable question in New York, in the federal courts in New York. The Second Circuit has decided it's irrelevant. If you decide to file a lawsuit against your employer and he hires an attorney, the attorney can't even ask about your status in that lawsuit because it's completely irrelevant. So I think that fear needs to be suppressed. The second fear, of course, is, well, I need a job, right? I need to feed my family. And if I file a lawsuit or I try to stand up for myself and I try to demand what rightfully is mine, right? Appropriate wages that's regulated by statute. If I stand up and try to demand my rights, what's going to happen to my family when my boss fires me, right? Because logically you're thinking, if I sue my boss, the next day I get to work, he's going to tell me, get the hell out, you're fired, it's over. And then you're stuck with a family or yourself or whatever, and no means to provide for them. So let me address that fear as well. I don't think that fear should stop you. And the reason for that is because there's a law, there's regulations in place that prohibits employers from firing an employee who's engaged in a protected activity. What does that mean? So if you decide to file a lawsuit against your employer, for instance, and let's assume your employer wasn't paying you minimum wage or wasn't paying you overtime, and you decide to file that lawsuit. You walk into work the next day, your employer sees this lawsuit and loses it and goes, get out! You're fired! How dare you? How dare you sue me? He's in for a world of trouble, right? Because now, not only does he have wage claims to worry about, or she, but now they have retaliation claims to be concerned about. And retaliations claim oftentimes carry with them punitive damages, because the whole idea of the law is they want to protect the employee. Obviously, they want to protect him from being fired or her from being fired. They don't want to see them being retaliated against by their employer. Otherwise, nobody would file a lawsuit because of that fear. So understand there's mechanisms in place that would prohibit your employer from firing you just because you stood up and demanded to be paid what you're appropriately due, right? And so these are the two common fears, and I want you to know that you really shouldn't fear them. And it should give you some comfort that there are mechanisms in place to tackle these fears, because the law is designed for you to stand up and demand that you're treated fairly under the law and under your employment contract. So now let me segue into what your rights are. Now that we've tackled the fears are behind us. Now we're going to stand up for ourselves. And to stand up for ourselves, we need to know, what are our rights? As an employee in the state of New York, as an employee generally, there's minimum wage laws that protect you. And I'm sure everybody's heard of it. In New York, currently in New York City, the minimum wage law is $15 an hour. $15 an hour for the first 40 hours worked. After the 40 hours, you are entitled by law to overtime, which amounts to time and a half. So, suppose you work 50 hours in a week and you're not an exempt employee, right? So you'd have to be paid $15 for the first 40 hours, which is $600, and then you need to be paid time and a half of that $15, which amounts to about 23, I'm not a mathematician, I don't have the calculator in front of me, around $23, and for the next 10 hours, that is the rate that you're going to be paid on, because that's the overtime rate. And for those who's just joining us, really, I would love for you to rewatch this video and rewatch the beginning parts, because we tackle the fears that many people have, the mechanisms in place to prevent you from being fired for bringing such lawsuits, and the mechanisms in place to prevent questioning about your legal status in this country if you decide to bring this lawsuit. So continue on the train of thought here with the 40 hours, right? Now, most people know minimum wage is $15 an hour. What most people don't know, and where the problems lie, is usually in a flat salary. It is very common in New York, it is very common all over this country, for employers to want to pay an employee a flat rate salary that would compensate that employee for any of the hours that they worked. And so a typical example would look like this. An employee goes to a deli, asks for a job, and they tell him or her, sure, we're willing to pay you $600 a week. We need you to come in 9 a.m., leave 9 p.m. every morning, giving a schedule for 6 days a week. Now, obviously, those times go over 40 hours, but the employee sometimes thinks, well, I'm being compensated on the week, so I'm not getting paid by the hour, so these FLSA laws typically cannot apply to me, right? And that's where you'd be wrong. Because in order for your employer to legally pay you a flat rate salary, you have to fit in into an exemption, right? There's exemptions to the FLSA, and so one exemption is the managerial exemption. What is the managerial exemption? Well, it says that if you perform duties of a manager, such as, and the minimum is supervising 2 or more employees, non-manual labor, and you have some authority, independent authority, making decision powers, then you can be classified as a manager. But at the same time, you also have to be paid a minimum salary. Now, the federal minimum salary for that exemption is typically low. It's about $455 an hour, a week. However, under New York, the minimum salary is over $1,000 a week. And so many people feel like they fit into that managerial exemption, but they would fall under it and would not qualify for managerial exemption on the employer side if the salary does not meet the appropriate threshold. There's other exemptions as well, but the salary component is always relevant. Now, most workers in reality are not exempt. They need to be paid time and a half. What does that mean now? How should you be treated? And now I want to give you what a legal employer does. Assume you are a non-exempt employee. You get hired. The first thing that your employer needs to do is give you something or comparable to it of an LS-54 form. This form puts you on notice as to how much you are making and what's your pay schedule and when you get paid, right? The law is designed because they want you to know. They want you to be able to have this piece of paper so you can track yourself week by week and understand, okay, my boss is paying me $15 an hour, or I'm supposed to be paid on Tuesday and today is Wednesday, where's my money? So this puts the employee on notice so there isn't any confusion in terms of how much that employee is getting paid or when that employee is going to get paid. So that is the first form that the employer has to give you, and you have to sign it, and he or she has to provide you with a copy of this form. If they failed to provide you with a copy of that form, that's a violation under the law, and the employer or you are due $50 a day, maxed out at $5,000. So assume you worked for somebody for 6 months, but you've never received a pay rate notice, then the violation under New York labor law at this time is $5,000, which goes to the employee, plus attorney fees for breaking this case. So that's step number one, and that's $5,000 in the bank. Step number two, how do you get paid, right? Some people get paid cash, some people get paid check. Relevant of how you're getting paid. And a lot of people tell me, well, I got paid in cash, so I don't think I can bring this lawsuit. Nonsense. You can still bring the lawsuit, because at the end of the day, and I will talk about this a little later, the burden is on the employer, not on you, the employee. And so assume you're getting paid weekly or bi-weekly, and you're getting a check or you're getting cash. What has to be provided to you is I'm going to use this simple term for it, a pay stub. But a pay stub that has all the appropriate information in it, such as how much you were getting paid, the hourly rate, the hours you worked, what deductions, tax deductions were taking, your name, your last four of a social, a phone number, whatever. The legal information needs to be on that pay stub. Assume you don't receive that pay stub, that's another $5,000 violation if you worked for, let's say, 6 months, or because it maxes out at $5,000, or $250 a day every day they don't have it. Maxed out at $5,000. So far we have $10,000 in the bank, and we have not even proved that we worked an hour of overtime, nor have we even proved that we were paid under the minimum wage. It's just these technical regulations that the employer has not complied with. Now moving forward to your work schedule. Assume you're working on a weekly salary. The law will ignore the weekly salary and asks you, how many hours a week did you work? You may tell me something. You may look, Abe, I have a problem. Yes, I worked 90 hours a week. Yes, I worked 80 hours a week. Yes, I worked 60 hours a week. But here's my problem, Abe. I don't have proof. How am I going to show that I worked these hours? My boss never had me clock in and clock out. What am I going to do? Am I screwed? And this is the beauty within this law. It is not on you to keep track of your time. It is on your employer to keep track of your time. So look at this question the other way. If your employer didn't keep track of your hours, if your employers didn't have you clock in and clock out, and you did, to the best of your recollection, right, because nobody's a robot, worked around 70 hours a week, and you go to court and tell the court, that is what I worked, that is the best of my recollection, I worked 70 hours a week, the employer will have to come and show records. When he or she doesn't have those records, then the court will presume that you, the plaintiff, the employee, are telling the truth. And then the burden would stay with the employer, because the burden's typically with the party that is more likely to be able to show evidence in support or against certain claims. And so that would be the employer in this context. And if the employer doesn't have records, then you have a presumption that you're right. And so he or she needs to overcome that presumption. That is not easy at all. I do a lot of these cases on the defense side, and I can tell you, if we don't have records, it's a challenge. It's a big challenge for the employer. And so if you don't have records, if you were never asked to time in and time out, don't worry about it. Again, as long as you remember working more than the 40 hours, as long as you remember getting paid under minimum wage or not overtime, there is still a claim for you, and you're actually better off than the employer. So let me give you a typical case that walks in so you can understand the type of damages that we're talking about here, and whether this is something that's worth exploring, which I definitely think it is worth exploring if you fit into one of these categories of an underpaid or mistreated employee, or an employee not treated as the employer is supposed to treat you under the law. So I had one client come into me and go, listen, Abe, I was paid, and we'll go back to this hypothetical, I was paid $600 a week. You know what? Let's make it even better. I was paid $1,000 a week, and I worked 50 hours each and every week. There's no breaks. 50 hours straight. I wasn't a manager. I wasn't an exempt employee. I just rolled sandwiches at a deli. And I was paid $1,000 a week. Now, that person may think, look, I'm getting paid great, right? 50 hours, $1,000 a week, but there's still a violation. How much is this violation going to cost the employer? So I'm just going to pull out my calculator, and we'll go through this hypothetical together right now. Assume you were paid a flat $1,000 salary a week, right? For 50 hours. So the first thing the court would do is take this $1,000 and they would divide it by 40 to determine what your rate of pay is. Because remember, you need to be paid an hourly rate. They're not going to assume it's the minimum wage. They're going to take the amount that you were paid on a weekly basis and divide it by 40, assuming that that amount of money, that $1,000, did not intend to compensate you for the 50 hours. Rather, they intended to compensate you for the first 40 hours. Now, this applies 100% of the times for any restaurant or food-related or hospitality because of New York's wage and hospitality order. This could be argued where it could be a different calculation if you're in a different industry. Again, the law is on your side, but there is a different calculation where they divide by the total amount of time, 50 hours, and just pay you for the half time for the last 10 hours, right? But here we're assuming the typical hypothetical. $1,000 a week, 50 hours, it's a food hospitality business. So you divide the 1,000 by 40 and you get $25 an hour. So now you know what your pay rate is. Your pay rate is $25 an hour. You take that number, you multiply it by 1.5 to determine what your overtime rate is. Because if you remember what we stated, your overtime is 1.5 your regular pay rate. So 25 times 1.5, you get 37.5. So your overtime rate is $37.50. Now remember what I told you, that by law, that $1,000, and we're taking the more common way of calculations, by law, that $1,000 is treated to only compensate you for the first 40 hours, which is how we reach $25 an hour. So what do we do with the other 10 hours, the last, right? Because we work 50 hours, and 50 minus 40, you get 10. What are we doing with those 10 hours? That's our damage. That's what we've been damaged, right? We weren't paid the time and a half for those 10 hours. So what we need to do is take that 37.5 number that we got, and we multiply it by 10, the amount of overtime hours that we weren't compensated for. That gives you $375 of underpayment per week. Now, the law says one more thing. If you were underpaid, there is liquidated damages 100%. You will almost always get liquidated damages. So what does that do? Liquidated damages mean that 375 number I told you, now you can multiply it by 2. And so now you've been underpaid by $750 per week. And now all along you're probably thinking, wow, I was getting paid $1,000 a week, 50 hours, I'm making good money. But in reality, you were underpaid significantly if you weren't exempt. And you weren't paid according to the law, and you weren't paid with a notice and overtime, and you were just getting paid a flat salary. So $750 a week is your underpayment. And assume you worked there for a year. You multiply that number by 52, and your underpayment for that 1 year is $40,000, about $39,000. Interest, we'll get to 40. Now let's talk about those notices I told you about. The pay rate notice, add another $5,000. The statement notice, add another $5,000. So you're talking about a $50,000 damage, about, plus your attorney fees, for paying you a flat salary of $1,000 a week, regardless of the number of hours a week you worked, and you working 50 hours a week. So you understand people are mistreated much worse than these. So the damages on these cases can often hit hundreds of thousands of dollars. And the most saddening thing about this is many people don't even know their rights under this regulation. Many people are still afraid that their boss is going to terminate them. But as I said, and I want to end the same way I started, these fears should not stop you from standing up and demanding equal treatment, proper, fair, legal treatment under the law, because there are mechanisms in place that have already thought about the retaliations of employers and how that could deter employees from coming forward and standing up and fighting for their rights. And so those mechanisms, like I stated in the beginning of this video, retaliation and the inadmissibility and the objectionability of even asking whether someone is a documented or undocumented employee in this country, according to Second Circuit law, which is New York, Southern District, and the Eastern District. That question is completely improper. If a plaintiff's attorney would even, if a defendant's attorney would even ask it, we'd object, call the judge, and the judge would ream out the attorney that asked about the status of a plaintiff in an FLSA lawsuit. As to retaliation, you should have no fear that your employer is going to fire you, because in most likelihood, their attorney has already instructed them that if you fire this employee, it's going to be 100 times worse off for you, because then that employee can add a claim to the complaint for being fired. And that claim is a claim under retaliation, which carries with it punitive damages. And punitive damages are damages that the court determines, or jury determines, are harsh enough, or fairly harsh enough, to deter any employer, or this employer, from repeating that same act of firing an employee who stood up and demanded their rights in the future. So you can imagine it's dependent on how much money the employer has, and that those damages can grow out significantly. So those two fears I think we've tackled. If you have any questions about your rights as an employee, you can call us. We're here for you. We'll speak with you for free. We charge no money to have this discussion. It's completely free. It's completely confidential. And to me, my whole life growing up, if it's free, it's confidential, there's nothing you're going to lose talking to an attorney, understanding your rights as an employee so that you can stand up for yourself, your loved ones, and your family and friends and advise them of their rights. So please feel free to call us. Our number is 212-840-0050. And we're Cohen and Tucker. We're here for you. And we're always open to listening to you and helping you in the future. And thank you so much for joining me here today. And I hope to see you soon. Thank you.